I'm David Griffith with the LGBT Elder Initiative, and thank you everyone for joining us. We are very fortunate to be joined by Ronda Goldfein and Rebecca Richman from the AIDS Law Project of Pennsylvania. As folks may know, we have done, as the Elder Initiative and the AIDS Law Project, have done a series of legal clinics for several years, going back several years. We actually had one scheduled for the first weekend in May, which had to be canceled for obvious reasons. But the AIDS Law Project reached back out this fall, knowing that this was an important time to still be getting this information out there, and that, you know, with the pandemic, folks are really thinking about what documents you need to have in order as we all navigate this new normal that is not normal at all. So just a couple of notes on Zoom. Those who have been with us before know this, so you are able to type into the chat. So if there are any questions or comments that come up as Rhonda is presenting, you can add those into the chat, and they have said that they're happy to sort of take those as we go. There's also a Q&A feature. If you get onto the bottom of your page, the bottom of your Zoom window, you can hit the Q&A tab, and it will come up another way that you can submit your questions. There's also an option to do those anonymously if there's anything personal that you don't want your name attached to. And for anyone watching us on Facebook, you can put your questions right in the comments field, and I will relay those to Rebecca and Rhonda. So that said, I'm going to turn it over to Rhonda to get us started today.
Thank you, David. And although I don't see your smiling faces, we do know you're there, and we appreciate your interest. So the AIDS Law Project, for those of you who may not know, is the nation's only public interest law firm. We've been providing free legal services for, let me think about this, 32 years. Let me get my math together there, 32 years. And we have been, we like to think, a valuable member of the community, and we were so impressed with the work that the Elder Initiative has done to serve the needs of that community that many years ago we reached out, largely at the urging of Ed Bomba, for those of you who remember Ed. And we said, look, we believe that having estate planning documents is so important that we want to offer this service for free to your member population, even though they may not be eligible for our services because we primarily serve people living with HIV. So as David said, we've been doing this webinar, or this service, not webinar, for some time, but now we're going to do it slightly different. So I'm gonna go through some of the basic information about the documents, but I really want us to have a conversation. So please feel free to send any questions you have through the chat or through the question and answer. I really believe that we have a more full and complete conversation if we can talk to each other if questions come up. I know that when I listen to things, I don't like to wait till the end, because then you're a little bit confused about what it all means. So please, let's have a conversation, not just me kind of talking to you. So let me back up for a minute, though, to say that the AIDS Law Project has been working remotely, as almost everyone else, except for the essential frontline workers, has been. We've been remote since March 13th. We are, however, still completely accessible. And so Rebecca's going to put into the chat the phone numbers that you can reach the AIDS Law Project. We have two numbers set up. So there's our main number, the 215-587-9377 number, and they'll go in the chat if you didn't get that. We also have a Google number, 215-821-7899. The difference between the numbers is that the Google number, our staff gets your message. So the second one is the Google number, the 821 number. Our staff gets that message in real time so that we can get right back to you. Our office number, we check several times a day, and we still get right back to you, but it's the 821 number is more of an immediate action. So please feel free to call us on that number. You can also reach us at our AIDS Law Project website, aidslawpa.org, and Rebecca will put the website in the chat. There it is. And you can go to that website, and we have an online intake form. This is a new feature that we've developed because we wanted to make sure that we were able to reach our clients. And then finally, for those of you who may have used our services before, we previously had intake hours Monday through Friday, 9:30 to 1. But during pandemic hours, you can call us all day long. We want to be there for folks. And our services have been continuing on largely the same as it ever has been. You know, the AIDS Law Project was born of an epidemic, and we've served our clients remotely throughout our 32 years because that's the model we set up. So we are prepared to do that, and we'll continue to do that. So there's all the information on how to reach us. Okay, so let's talk about documents. And the thing that I want to say is that I've done a whole lot of documents for people. I've been at this job a long time, since I was a little girl. And we noticed that people, even those who may be apprehensive about doing their documents because it sounds very, very final and perhaps you're tempting fate, but in fact, people say the same things. So the two things we hear all the time about people doing them is, that was a whole lot easier than I thought it was going to be. And I have a lot of peace of mind now that I've done it. Like, it's just about taking care of business. Whatever your needs are, you take care of that, you get the peace of mind that that's covered. And so we hope that if you reach out to us to have us prepare your documents, you will have that same experience. So let's talk about what the documents are. So the first thing that we prepare for folks is a last will and testament. This is your basic document that allows you to name who you want to take care of your possessions after you're gone, and allows you to direct them to the people who are important to you. We often talk about, this whole concept of probating a will, if you imagine, is, so I draft a will. And I say, I want Rebecca Richman to make sure that my best lipstick is given out to my dearest friends. And that she then goes around with her wheelbarrow to collect all my lipsticks, and then she distributes them to my friends. And that's an oversimplified version of what the executor of a will would do and how probate would work. So it gives you the opportunity to identify who's the person you trust to make sure your possessions, your money, your property, your lipstick, to make sure that's all distributed, and then to specifically identify who you want to have those things. Now, you also, for some people who say, well, I don't want to do all of that breaking down of, I want this person to have 5 boxes and this person to have 3 lipsticks and this person to have $10. You can also divide what you have by percentages. So you can say the value of my bank account, I want 10% to Rebecca Richman, I want 10% to David Griffith, I want 10% to Chris Bartlett. However you want to divide it, but you don't need to worry about the level of precision. If you have a precise idea in mind, that's perfect, and we can incorporate that. But I often hear from folks, well, I haven't figured all the math, and what if I don't have enough money to distribute the way that I want? We can account for that, all of that, in a will. If I say I want to give David Griffith the Ben Franklin Bridge because I admire his work so much, well, at the time of my passing, if I don't own that bridge, I can't give him that bridge. And what I use that example, which is a little silly, but I use that example to say that you needn't worry that at the time of your passing, if you don't have the thing, you've given to somebody else in your will, right? This is, as we sit here today, what are our wishes about distributing the property that we have or may acquire, and who do we give it to? Pretty easy stuff. You have the opportunity in your will to name an executor. So I name Rebecca Richman to make sure that all of my property is distributed in accordance with my wishes. Suppose Rebecca is unwilling or unable to serve in that role. I can say I name David Griffith as the alternative so that I'm covered, so that I know that I will have the peace of mind that people I trust have assumed the obligations that I have asked them to take on for me to make sure that my property goes to where I want it to go. So a will is signed by the testator. That's the fancy name for the person who makes the will. And then we have two witnesses and a notary. And so the witnesses are confirming that I signed my will, that it was me. And then the notary is confirming that, yes, that it was me, and that the witnesses are who they say they are, and they knew it was me. So it's pretty basic stuff. And we would be happy to do that for folks, draft wills. Any questions? Are we good? No? Okay. The next document that we do for folks is a medical power of attorney. Now, you've heard people talk about power of attorney documents. At the AIDS Law Project, our practice is to separate them into two. So we have a medical power of attorney and a financial power of attorney. The medical power of attorney is what it sounds like, I name someone else to make medical decisions on my behalf. The will that we talked about, the will only takes effect when I pass, right? Because I have until, as long as I have a dying breath, before my dying breath, I have the ability to change my document. So it only comes into place after I die. That's when it takes its legal effect. A medical power of attorney, however, is valid as soon as it's signed. So let's say I meet with a lawyer from the AIDS Law Project. We prepare my medical power of attorney. I name David and Rebecca my power of attorney and my alternate. No matter where they are, as soon as I sign that document and it's properly witnessed, they have the legal authority to make decisions, medical decisions on my behalf. Now, that authority extends to the point of any incapacity, which is really, the kind of the value here, that we want somebody to make medical decisions when we're unable to do so. But I'm competent today, I signed my document, I named the two of them. They can also make medical decisions on my behalf now. The document doesn't take effect only once I become incompetent, if I should become incompetent, but it takes effect immediately as soon as I sign it. So let's say there's a medical decision to be made. I'm competent, but I'm nervous and I don't want to make it. And I say, Rebecca, you're so smart, please you decide for me. She would have the legal authority to make that decision. If, however, I'm competent, even though she has that authority, if I say, oh, yes, Rebecca, you are so smart, but I disagree, in that instance, my wishes will still take priority. So medical power of attorney, it's valid as soon as you sign it. A will, only the original is valid. You have an original signature, and we keep those in a safe place. A medical power of attorney, a copy is as good as the originals. So what we encourage people to do with power of attorney documents is make sure that the people around you have access to it, right? If I've named Rebecca to make medical decisions for me, but nobody can find that document, then it doesn't really serve me. And so I would give a copy to Rebecca. If David's my alternate, I would give a copy to David. I would give a copy to my doctor. If I had a case manager, I would give a copy to my case manager. I would keep it with my other important papers where I live. And so the idea is you want people to have access to it, and because the originals are as good as copies, that can happen. That document doesn't need to be notarized, simply witnessed. So that's a medical power of attorney, pretty simple. If you've ever gone in for any type of medical procedure, your healthcare provider may ask if you have a medical power of attorney. The other document is a financial power of attorney. Now, that document is what it sounds like, that it gives people the authority to make, I can name someone to make financial decisions on my behalf. So let's say I say, Rebecca, you're so smart. I want you to make financial decisions on my behalf. She can make them as soon as that document's executed. That document, because there's other powers involved, is more complicated than the medical power of attorney. So in that document, I have to specify what powers I'm giving to Rebecca. And so there's and you can see the forms. In fact, Rebecca's going to put the link to all of these documents, drafts, in the chat, and you can take a look at them at your leisure. The link is going to take you back to the AIDS Law Project website. So in case you don't get to look at them during this session, that's where it can be found. So the financial power of attorney has a lot of different powers that you can decide. So suppose I want Rebecca to be able to sell my property or make gifts or change my bank accounts. I can designate which specific powers I want her to have. And once that's signed and witnessed, and there's the link, and then she has to sign that she accepts that and she wants that authority. But again, not that complicated. We often say with a financial power of attorney, because you're giving someone else great authority over your life, that you should think about. I mean, you're going to think about all these documents, of course, but because the financial power of attorney will be effective as soon as it's signed, are you ready to give someone else access to your financial accounts? Are you ready to let someone else have that authority? And so we often, talk through people with a power of attorney, what their goals are, what they see their needs are. If you're concerned like, oh, I'm going to have a procedure next week, and I want to make sure that somebody has the authority to pay my November rent, then maybe you would limit the power to just that thing, right? I want Rebecca to make sure that my rent is paid for November, but I'm not quite ready to authorize her to change my entire estate plan, move all of my accounts around. Not that I don't trust Rebecca, and I in fact do and would, but to be clear that you retain the authority to kind of limit the powers based on the circumstances that work best for you. The other thing to keep in mind about a financial power of attorney, okay, I see a question. What happens if the financial POA abuses the power of attorney? So if you believe there's some abuse, the first thing you want to do is void the document. You want to go to wherever that document may be on file, whatever financial institution that document may be on file, and tell them that you're revoking the power of attorney, you're voiding it, and that person doesn't have the authority any longer. For the extent, from the moment that you give the person the authority to the point where they begin to abuse it, a financial institution has the right to rely on that. Now, we can think of some extreme examples. Maybe the financial institution should say, well, wait a minute, something doesn't seem right here, and they may look at it more closely. But the institution has the right to rely on the document up until the point that you revoke it. So you want to be sure that if you name someone, that it's someone that you can trust. With regard to financial institutions, sometimes we want to, the reason why we execute these documents is that we want to be sure that there's kind of quick turnaround. Like if I need Rebecca to be able to pay my November rent, I don't want her to struggle at the bank. I want to make sure the bank will honor her signature. Oftentimes the bank, when you walk in, here's my financial power of attorney, I got it from the AIDS Law Project, I know it's done completely right, the bank will say, great, we're sending it to our legal department and we'll get back to you in 2 weeks to let you know our assessment. That's happened to some of our clients. Now, the bank has always come back later and said, yes, it was done in order, it was done correctly, as we knew it would be, but there is that lag time. What we encourage folks to do to avoid that lag time is to make sure they sign the financial power of attorney at their bank. So, because when you walk in with the AIDS Law Project form, the bank will say, well, we don't know what this form is, we're not sure, we have to get our legal department to review it. If you walk in and if I have already designated Rebecca on the bank's form, the bank looks in their system and they say, yes, she's been recognized and she can begin to immediately transact business on my behalf. So if you're concerned about any kind of lag time, it's best to go to your financial institutions. And depending on the financial institution, some you can do the full, well, in COVID times, it's a little bit more difficult how we do all of these things, but I would check with your financial institutions to see how you can execute those forms, make sure they're on file, and then keep a copy of everything you signed so you know that if you ever need to change any of your documents or rescind them, you know which financial institutions are holding them. Okay. Questions about, other questions about a financial power of attorney? Okay. The next document is a living will. You may have also heard of this as a do not resuscitate, which kind of has a more somber tone than a living will. But a living will is similar to a medical power of attorney. That's a document that allows me to decide what my wishes are for end-of-life care. And different from the medical power of attorney where I said, Rebecca, you're so smart, please make all those decisions for me. I trust you to make informed decisions. In a living will, I make my own decisions. I decide what I want, and I say, Rebecca, I trust you to make sure that my wishes are enforced. And if you have ever been in the difficult position of having to make that decision for a loved one about, do we continue long-term care? Is this the end of this type of care? If the loved one has already decided and all you have to do is respect their wishes, that's much different from having to be in the position of making that choice. And so we encourage people, have your choices known. Think about what you want. We also think that it's important when you name someone to make sure your wishes are carried out, that you name someone who shares your beliefs about end-of-life care. And so I used to say that, my late mother, I would have never, although I loved her dearly, I would have never named her to make sure my wishes about end-of-life care were carried out because she didn't believe in that. She was like, where there's life, there's hope, everybody stays alive forever, it's really great. I'm like, I love that idea, but it's not exactly the ideas that I have. And so you wouldn't want to name somebody who didn't share your philosophy about end-of-life care, or at best would respect your wishes on end-of-life care. So again, all of these documents are about thinking about who's the important people in your life, who do you trust, who do you rely on, who will make sure your wishes are carried out. So the living will you have just like the other documents. You have the opportunity to name the person who will make sure your wishes are carried out, and then an alternate if necessary. We generally recommend, but not required, that whoever you decide to name as your medical power of attorney, that's the person you're saying, I want you to make the decisions for me, that you then name the same person to say, I have made my own decisions, and I want you to make sure those decisions are honored. It's not required. And if you meet with us to do documents and you say, I want Rebecca to be my medical power of attorney and David Griffith to ensure that my living will is carried out, we will ask, why are you naming different people? Just to ensure that you have thought this out. So Rebecca, you're asking, can you
name someone as your appointee without having asked them, or do you need their permission to list them?
That's a good question. The financial power of attorney, the person, your agent that you have designated to make the decisions, they have to affirmatively accept that authority. They have to sign the form and say, yes, I understand this obligation and I'm willing to do that. The other documents, whether it's your executor or your medical power of attorney or the person that you've identified in your living will, they don't have to agree to it. They don't have to consent to being named. But you want to think about, is that something that you want to drop on people? Is it something you want to assume that somebody will be okay with? Is it somebody that you haven't had the conversations about your views on healthcare or your views about your property? So it's kind of a long answer. You don't need their permission, but just in terms of good practice, I would say that you would want to tag them into that conversation. Very good question, Keith. So Keith has asked about COVID and ventilators, and has access to ventilators during a time of COVID. Can that be specifically provided for in your medical power of attorney? So a couple of things. The medical power of attorney, as I said, it's effective as soon as we sign it. So, we always talk about the kind of, like you leave here, you get hit by the bus, somebody's got to save you. If my wishes are in my medical power of attorney, if I have designated Rebecca to make decisions for me, Rebecca may say, well, she never liked the idea of being intubated. We're not going to do that now. I can make some specific directions both in my medical power of attorney and in my living will. I can say, I specifically want this. Now, once again, the medical power of attorney is effective as soon as we sign it. The living will is not effective until a person is in what they're calling what's known as a permanent state of unconsciousness, that two doctors will certify this person, despite all the effort, all the care we give them, is not going to, in our medical opinion, is not going to improve. That's when they look at the living will. So you got hit by the bus walking outside, we get taken to Jefferson, which is a few blocks from here. They are going to provide me with all the care I need. only should I pass to a point of unconsciousness would they say, okay, now let's look at the living will and see what her wishes were about a mechanical respiration. But we can make specific provisions in our medical power of attorney and in our living will. We can say, if I am short of breath, or more than short of breath, if I'm struggling with breathing, and that the protocol is during this period that I have COVID to put me on a ventilator, then I agree to that, I want that. If folks are concerned about that, we can have that amendment in their documents to make sure that your wishes may differ depending on the period of time that we're in, right? So right now, people may say, people who would never have considered mechanical respiration may in fact say, well, but if it's COVID and I can be cured or returned to health, then I do want it. So we can add those provisions into the documents. Similarly, we see in living will documents, people say, I want to be sure that I am pain-free. I want to put into my document that I don't want to feel pain and that I want medication to not feel pain. And we can do that. We have also seen for people who may have had, who are in recovery, who said that they don't want pain meds because they're afraid of losing their sobriety, they don't want to return to a life that they no longer live. We want to encourage folks, while it's always your choice in living wills, that to be kind to yourselves. So if a living will is only comes into effect when we are at a point in our life where it's a permanent state of unconsciousness and that you're not recovering, recovering to health, we want to encourage people to be not so hard on themselves about pain meds at that time in their life. I don't want to get beyond my lawyerly field about pain meds and recovery, but I just want to encourage people to be kind to themselves and think about what time in your life you're using those kind of documents. So a last document that we have is something called a directive as to remains. And that document allows me to designate where I want my remains. So I can use that to authorize Rebecca to pick up my body from the hospital, to make arrangements with a funeral home, to do those particular things. And we do that as a separate document because often people don't get to reading the will until after the immediate crisis that someone has passed. And so we just want to make sure that people have the opportunity to have every one of their wishes, no matter how big, no matter how small, excuse me, it's like fall allergies. No matter how big, no matter how small, to have them all documented. You know, again, in the our experience at the AIDS Law Project has been that people will say, I feel so much better that I got this documented. I got this done. It's off my mind. It also gives people an opportunity to state things that are really important to them. Like I recall a client so clearly who was adamant that he wanted to be buried in a red suit. And he, you know, and as soon as we got that on paper and he signed it, he was like, now I feel comfortable. And so I think that, you know, we want to, there are, as we know, a lot of things in life that we don't get to control. But at this part of life, there's a whole lot that we get to have control over. And so I want to encourage people to be thinking about that. This is an opportunity for you to identify the people who are important to you, the items that are important to you, and make plans that are going to give you peace of mind.
Can I ask chime in with a question on that, Rhonda?
Of course.
The directive for disposition of remains, that can also include the name that you want to be, if you're having a gravestone or anything like that, that it can be, you can choose how you are identified. Is that correct?
Absolutely, absolutely. I think that, that's the document that you'd want to use to make sure that, and if the other documents are about the care that you get up until the point you pass, the directive as to remains is kind of the document that explains what you want after you pass. So when we've done these seminars in the past, how we usually do it is that we say, okay, so now that we've told you about all of the documents, we're going to give you the opportunity to have breakout groups. We're going to assign everyone a lawyer, and we're going to end the day with, drafting everyone's document. So for obvious reasons, we weren't able to do that today. But what we would like to offer is, again, that if you're interested in the AIDS Law Project providing this free service to you, and you don't have to be eligible for our services otherwise, meaning even if you're not a person living with HIV, you can call our office. Again, the two numbers are in the chat. The 821 number gets you immediate service. The 587 number gets you a call back within 8 business hours. But call us, tell the intake advocate that you were referred by the LGBTEI, and we will contact you. We'll talk over the phone. We can do it by email, but kind of by phone is always best, to prepare all of your documents. And then we can meet you at a secure, safe place. For those of you living in Center City, we think that the William Way Center, notwithstanding the few steps in the front of the building, is a easier building to access than the AIDS Law Project office. We're just a few blocks away from the William Way Center, but there are now a lot of tenants in this building. There's essential workers in this building. There's a small elevator in this building, and so it's not ideal. If for some reason you would much rather meet here than the William Way Center, that's fine, of course, but we wanted to make what we think is the more accessible offer to meet folks at the William Way Center to execute the documents. And so we will bring the documents, we'll bring the witnesses, we'll bring the notary, we'll bring the face masks, we'll bring the pens, and then we will arrange to get copies to you so that you can feel secure with them. So, other questions?
I had one other question that has come up in some other programs before, but folks asking about if they don't have someone in mind to be their medical power of attorney or to put on their advanced directive, are there services out there where someone will fill in to be that power of attorney, or does it need to be an individual who especially for folks who maybe don't have someone in their life who they would trust with those responsibilities?
Yeah, so I think it depends on which organizations you're involved with. Oftentimes there's a conflict. I know in the AIDS service organization realm, folks feel incredibly close to their case managers or their social workers, but that many times the organizations or the healthcare provider dissuades their employees from being on folks' documents. And so there are some services, and I think it really depends on who you're connected to and who you're involved with. I mean, you certainly don't need an alternate, and I think I know that some folks have a kind of a smaller world, and it's hard to find somebody that you trust to make those decisions, and we can help you talk through that to think about, well, have you thought about this person? Have you thought about somebody from a faith organization, or whatever's close to you.
And I can actually address the other question that just came into the chat. So the William Way Center is still not open to the public, just for folks coming in, but we are able to set up appointments there. So this would be, you call the AIDS Law Project, you set up a time, and I, with the Elder Initiative, will be able to coordinate on the William Way side to get folks in at a time when there's no one else around and that it's safe for folks to come in. So yes, you have to call the AIDS Law Project and set this up first. Don't just come to the center hoping for these services. But thank you again to Rhonda and her team for making that offer available. Because we know this is, again, a time that folks had these concerns are really front and center for a lot of folks, as we've seen what's happened throughout the pandemic.
The offer for questions is not time limited. So if you later today or next week or whenever it is, you take a look at the documents that are referenced on the link that's in the chat, and you say, oh, now that I've had that chance to look at it, I have other questions, please don't hesitate to call us. Even if you just want to talk about the documents and you're not yet ready to execute them, we're happy to have that conversation with you.
Any other questions folks want to get in before we break for the day? Either those of you on Zoom with us or those watching on Facebook?
Okay. So I see one question about updating documents. Depending on when you did the documents and who did them, we can either update them or we'd be happy to do them over. I mean, we often say that because these documents reflect the dynamics of our life, that, it's always a good idea to revise them. If you've moved, if the people you've named have moved, if your relationships have changed, we encourage you to either update or do them anew. So if you have documents, but you want us to look at them, we're happy to do that. And if we didn't do them originally, we're probably going to offer just to do them new documents for you. Yes. So the question is, are these documents valid in other states? And yes, they are. There's agreements between the states that if I have a document that's legal in the state where it was executed, then it is legal wherever I travel with it, which is particularly important because we want to make sure that if we are traveling, which I realize is not happening right about now, but if we travel and if we end up seeking health care in a place where our loved ones aren't known to the provider, aren't recognized, that we have the document that said, no, this is the person who I'm authorizing to make decisions for me.
Just taking one last look at Facebook here.
Okay. Okay, so can you name more than one executor? So the way that it works is that you would name one. So I would name Rebecca, and then I would name David as the alternate if Rebecca was unable to serve. Sometimes we see people saying, no, I don't want to prioritize one over the other. I want to name them both as co-executors. That's legally permissible, but you just want to make sure that both those people get along with each other, and that the logistics are such that it makes sense. So for instance, if I lived here and Rebecca was in Philadelphia and David was in California, would it make sense to prevent or to impede Rebecca from taking any actions on my behalf until she could tag in somebody who was far away and on a different time schedule? So the short answer is yes, you can name more than one, but make sure that they get along. You know, this is not the time where you want your feuding children to try to get it together. And you want to make sure that it's logistically sound in terms of where people are physically located.
I have a question. I think I know the answer to it, but I'm going to just put it out there.
Okay.
So if I happen to get in an accident tonight before I call the AIDS Law Project to do my intake, to complete my documents, can I call you from the hospital tomorrow?
So the AIDS Law Project, I mean, this is kind of pre-COVID, but I'm sure we could work it out. We do home and hospital visits. We really are focused on meeting people where they are. And so that if you needed documents, we would go and do them in the hospital. Again, the COVID regulations are a little bit different, but we can accommodate folks where they are. And not to make folks uncertain, but the flip of that is, unless you have documented who the important people who your important people are, and what your wishes are, you do run the risk of, should you need health care, that the people who are close to you but may not have a legal standing won't have authority to speak for you or to even visit you. And we see that, you know, it feels like, you know, every few months we hear some horrible story about some horrible hospital in some horrible place that, you know, will exclude, you know, a person's partner because they're not legally married. These documents give you the peace of mind that the people who are important to you will have the authority to speak on your behalf.
Thank you so much, Rhonda and Rebecca, for taking the time here today. Oh, we just got one more in.
Yes. So the question is not to have co-executors, but to have sequential executors. And so yes, you can absolutely name a primary, an alternate, a tertiary, so that if the first person you named is unable or unwilling to do it, then the second person can step in. If the second person doesn't want to do it or can't do it, then you can go to the tertiary executor. And so absolutely you can, you know, these are the documents that really give you the opportunity to identify what's important to you. And so I want to say, you know, within reason and barely within reason, whatever it is that you want, here's where we can document it for you and to make sure those wishes are carried out.
I want to say also, for the folks who are on this Zoom with us, I will send you out an email with the link to the document that Rebecca had put in the chat, and also those phone numbers, just in case. And so you don't have to worry about recording them down right now. I will make sure you get that information today. And then also for anyone on Facebook or who's watching this video later, contact me and I can make sure you get that information. So again, big thanks to Rhonda and Rebecca from the AIDS Law Project for taking the time to chat with us today and share this wealth of information, and also for that offer to help folks complete these documents. And we'll help to coordinate to make that happen. So I think we are good for the day. Leave you with any last words if you want to share.
Take care, stay safe. We will get through this.
Thank you so much.
Thank you.